Good evening, everyone. I'm Edward Sullivan with the University of Toronto Men's Issues Awareness Society, and I'd like to thank you all for coming out tonight. UTMIAS has been active on campus here at University of Toronto since 2012, and thanks to some very generous sponsorship over the last 5 years, we've been able to bring in a wide variety of speakers to talk about critical issues affecting boys, men, and families. I'm particularly happy as a law student to see this many people out tonight, because usually when people start talking about things like the role of evidence, you get yawns or snores. However, Bill C-51, because it affects someone's ability to defend themselves against criminal charges, raises important legal, ethical, and constitutional questions that I hope our panelists will be able to provide some insight on. Tonight's event is sponsored by the Canadian Association for Equality. And because of that, I'd like to invite Justin Trottier up to say a few words. Justin is the executive director of CAFE, and he plays a substantial role in managing the Canadian Centre for Men and Families here in Toronto. Justin?
Thanks very much, Edward. Thanks to all of you for joining us tonight. For how many of you is this your first U of T Men's Issues Awareness Society event? Wow. And for how many is this your second or your, yeah? Okay, so it's a pretty mixed crowd. So let me tell you very quickly about the Canadian Association for Equality. I think it's a pretty unique charitable organization. We're interested in integrating the issues and perspectives of boys, men, fathers, and families into our efforts to achieve gender equality. We do that in a number of ways. The most, I think, consequential in terms of where our resources are invested these days, as Edward mentioned, is the facility known as the Canadian Centre for Men and Families, which actually is just that way, just a few blocks east of me, down on Jarvis, and you're all welcome to visit us. You can also visit our website to get more information, which is menandfamilies.org. We're very proud to have just opened a sister office in Ottawa, and we have plans to open offices in other parts of the country. One big initiative we're working on right now, and you might have been wondering why there's that slide above my head, and that is a GoFundMe crowdfunding campaign. We're trying to raise funds to open what would be Toronto's first, and so far only, shelter for male victims of domestic violence and their children. So this would be a family shelter. There isn't anything like that in Toronto. In fact, we've done our research on this. This would be the first such family shelter for male victims of domestic violence and their children in any metropolitan city in North America. So any major city of a population over 1 million, this would actually be the first, believe it or not. So we think that's a pretty big deal. We're running a fundraising campaign right now. This is in response really to the overwhelming demand that we've heard from our clients. Over 400 men just in 2017 have called us looking for such a space, many of them thinking that that's what we offered, but in fact we don't. We do offer a number of support services to male victims of abuse, but we don't offer a shelter. Nobody really does. That's why we're so excited to be making substantial progress with our fundraising. So very quickly, we have raised over $175,000. The project goal is $300,000, so we're more than halfway there. The GoFundMe campaign, we're just over halfway through that campaign as well. Now, if that's successful, then that will be matched, those $50,000, by one of our sponsors. So if you donate through the GoFundMe platform, your funds will be effectively doubled, but only till the end of the year. So we're trying to incentivize the community in Toronto to get behind this really important project. And I can tell you it would make a difference in the lives of many, many men and women as well, because this, again, would be a family shelter. We would be welcoming fathers with children. That could be sons, that could be daughters. So this is going to have a substantial footprint. We're very pleased to be getting support from police, from victim service agencies, and from a number of other important community partners, as well as various levels of government. So again, small window of time, you can make a donation with us tonight, or you can go to this website, which is gofundme.com/abused men shelter. Watch the videos. We've got some stories of some of the men who have been very courageous to talk about their experiences around domestic violence and the help or the lack of help that they got, and how much they're hoping that all of you will step up and make sure that we've got this haven for abused men and their families. So please, please do consider going to gofundme.com/abused men shelter. Also, you can sign up out front to get updates. You can make a donation here, as I said. You can buy merchandise. We have some t-shirts there. All those funds will go to this really groundbreaking project. Please be a part of that. Thanks very much. hand this back to Edward.
Thank you very much, Justin. Obviously, anyone in the room can get involved with CAFE, but for the students and faculty here, I would also like to encourage you to get involved in UTMIAS itself. You can find our Facebook page on Facebook, but there should also be a sign-up sheet outside on the table. Before I introduce our moderator, I do need to quickly remind everyone that the University of Toronto's policy on the disruption of meetings is in effect tonight. However, hopefully we will have some lively discussion nonetheless. Your moderator for tonight will be Lorne Honigman. He is a partner at Browdy Thorning Zabaris here in Toronto, but in addition to being an experienced civil litigator, he's spent several decades as a legal expert, journalist, and all-around personality for several different television and radio stations. Lorne, the floor is yours. Take it away.
Thank you. And welcome, everyone. Appreciate everybody coming as we have the debate tonight about Bill C-51, the Act to amend the Criminal Code and the Department of Justice Act. And what I'd like to do is introduce the panel, or that's called feedback. I usually get better feedback than that, but that wasn't bad. By the way, one of the things we'd like to do tonight, when we get into the discussion, we're going to get into all the areas of the new bill. There's a microphone down here, and normally when we run these types of discussions and debates, we go through it as a panel and we open it up to the floor. But what I'd like to do, if we can do it, and keep everybody's comments and questions to a very, very short a short period, if you want to come up, because we're going to be touching several different areas about the proposed legislation, about what's happening in the world of sexual assault trials, and of course specifically what's been happening since the Ghomeshi trial last year. So if you have any questions or comments, come up to the microphone, we'll try and get you in, and we'll try to do this like we would do it if we were actually doing a television or radio phone-in show to get everybody engaged if you have something to say. And of course, we'll do it at the end as well, but I just encourage you to try and keep your questions or comments as succinct as possible. I know sometimes it's hard, but let's try to do that. Let's first of all introduce the panel, or have the panel members introduce themselves. And let me start on my far right, and I'm not talking politically, I'm talking simply where he's sitting right now, Andre Marin.
Yes, hi, my name is Andre Marin. I was a Crown attorney for 6 years, prosecuted many sexual assault cases. I then became director of the special. I was a Crown attorney for 6 years in Ottawa, prosecuting many sexual assault cases. After that, I became director of the Special Investigations Unit, investigating the police. After that, I was the military ombudsman, and most recently, the Ombudsman of Ontario. And I have been a lawyer since 1991, I believe. So that pretty well ages me. And I do apologize, by the way, for delaying the proceedings this evening. When I punched the address on my nav, apparently there's two Banting Institute. The real one, where it's full of chemists and labs, and this one. So my Apple map sent me to the other one. So, and all these chemists were wondering, what are you talking about? There's no sexual assault conference here. So anyways.
Well, don't worry about Andre. Joe was about to bring an unreasonable delay application.
Okay,
so,
fair enough.
But you know, you got here just in the nick of time. Next panel member, Diana Davison. There you go.
Waiting for the feedback. Okay. My name's Diana Davison. Some of you might know me from YouTube. I'm a civil rights activist and a advocate for the falsely accused. To that effect, since March of this year, I'm co-founder of the Lighthouse Project, where we offer our services for free, crowdfunded to people who've been falsely accused of sexual assault or domestic violence. And a lot of people want to know how we know. Well, it just takes a lot of investigation and stuff we do first, and I can tell you I'm working with people from Canada and the United States, as well as sometimes the UK, Germany. We get random contacts, so it's kind of an international thing. And I've been really pleased with the awareness that's been growing about false accusations, more and more articles in the news featuring like the horror that these people go through. I've been following Bill C-51 since it was first hit the news, because it's my concern that if this bill passes, which it looks like it will increase the number of wrongful convictions. And aside from just falsely accused, I do help people who've been wrongfully convicted, and those are the saddest cases of all.
All right, thank you. And last, but certainly not least, Joe Newberg.
Good evening, everybody. I'm Joseph Newberger. I'm a criminal defense lawyer. I've been practicing since 1993. I'm a little distressed to find that Andre has been practicing for 2 years longer and I look like his father. But aside from that, I'm a criminal defense lawyer, but my perspective with respect to cases involving allegations of sexual assault has come from my practice, but also I've acted for government, most notably in the Cornwall Public Inquiry, where I represented the Ministry of Community Safety. So I have a considerable perspective from the other end, and I was involved in structuring policy and dealing with issues with respect to male victims of sexual violence as well as female victims. I've done some prosecution work for the ministry as well, including prosecution of OPP officers, some of which included sexual allegations. So I have a broader perspective than just simply being a criminal defense lawyer.
All right. So there's a little bit about the panel. Let's go to the highlights, if you will, with respect to what Bill C-51 is going to do. And I take it somebody's on the PowerPoint with me. Can we move to the next slide? All right. Next slide. And yeah, and let's just go right to the next slide. There we go. So what it does, it expands the sexual assault law in sections 273, 276, and 278 of the Criminal Code. And here's the three key areas, and this is what we're going to focus on. One, it clarifies that unconscious persons can consent. And would be an interesting discussion about that. I know lots of people have written about it. That seems quite obvious. Why would you ever have to codify some type of section like that? So we'll get into that. The second one, it expands what material is subject to preliminary evidence hearings. The third expands prior sexual history to include anything of a sexual nature or sexual purpose. We go to the next slide. Now, this includes text messages, emails, videos in the possession of the accused, and that's very controversial. I know that's causing people like Joe a lot of angst, and we're going to get into that issue. And then finally, it gives complainants legal standing and representation in applications to use the evidence. So that really takes the highlights, if you will, summarizes it. But I want to start with you, Joe, because I've known Joe a long time. We've worked together on many different radio shows, and we even cases. And I wouldn't say that you have a tendency to overreact, but when I read
someone in this room might, but
yeah, but when I read the word you used, and I want to start the discussion with that. You said this would be catastrophic. That was the word you used.
Yes.
Tell us why you think that.
The nub of Bill C-51, which I find so significantly challenging in our context, is the shift now away from prosecution bearing all of the burden to essentially shifting on an accused the obligation to provide disclosure. This is, in essence, where there's an expansion with respect to evidence that an accused person may have that they'll have to disclose. So let me just expand it in case everybody knows. So in sexual assault cases, up till now, anything involving prior sexual history, of course, had to be vetted through Section 276 for obvious and understandable reasons. But anything in relation to the subject matter of the offense that the person is charged with has always been something that is fair game. And we have never been under an obligation, an accused person or the defense, to provide defense disclosure of evidence in our possession. Now, with this new legislation, there will be a positive obligation to disclose anything in our possession that we wish to use for cross-examination. Not just about prior sexual history, which is appropriate, but about the subject matter of the offense. And the disclosure in that regard will be then subject to a hearing for admissibility, for which the complainant will have standing and will have counsel. This is a monumental shift. It is an erosion of the right to a fair trial, and it is significantly an erosion in an ability of an accused to, in my opinion, be able to mount a defense and in my opinion, it's an erosion of the presumption of innocence. It is essentially a knee-jerk reaction to one particular case where there is the desire to make the process easier to prove an allegation and erode the right to defend it.
Well, I just want to hop over to Andre for 1 second, because Andre, you were crowned in the Derrick case back in 1990, in 2000, I'm aging you a bit, in 2000. That was changes to the criminal code about restriction, about admission of evidence related to a complainant's sexual history. And I remember I read something where you said people like Joe Neuberger back then were saying the sky is falling, and if I understand your position, that's what Joe is saying right now, you would call an overreaction.
Well, I mean, it's an opinion that I don't share, let's put it that way. Right now, if the defense wants to adduce evidence of prior sexual activity, it is bound by certain very strict criteria in the criminal code to prevent what is called the twin myths, that a complainant is more likely to have consented to sexual activity on the basis of her sexual experience, or is less believable. So those are the twin myths that the criminal code wants to attack. And I see the amendments here as an extension of that, so that there's a process by which those emails, text messages are vetted to ensure that the trier of fact is not stuck in the prejudicial, stereotypical way of thinking, but rather is dealing with probative evidence. And when Joseph talks about the fact it's unheard of, I can think of a lot of precedents that exist to deal with particular circumstances where the accused has to provide information to the Crown. For example, if the accuser raises an alibi, I wasn't there when the crime was committed, therefore I'm not guilty, notice must be given to the Crown. And if it's not given in an adequate, timely way, an adverse inference can be taken from that. When the defense wants to bring a charter application, it has to give notice to the Crown. It has to provide the court a legal and factual basis upon which the court will be convinced to enter into charter application. So there are many instances where, because of fairness and because of the circumstances of the offenses, that our criminal code makes amends to provide that the imbalance is rectified. I mean, listen, sexual assault has only been, since 1980, a crime where corroboration is not required. Prosecutions of sexual assault before 1980 required corroboration. Now, maybe I lived a sheltered life, but I've never had a third person in the room while I was having sex. So you can imagine a sexual assault. How do you prove it when it's a he said, she said, without corroboration? And that's only been fixed since 1980. So the laws evolve, and I don't think the sky's falling. I think this is a natural evolution of the rape shield provision, and I think it is constitutional.
All right, Diane, I want to get in on the conversation, and one of the things that both Joe and Andre dealing with, and let's talk about, because it did happen post-Ghomeshi, the discussion and what both parties are talking about here, where a woman now, it could be anyone, or a man, any complainant to have standing to be able to come to the court with a lawyer and say, look, here are these text messages. I don't want them in there, or I don't, but be able to discuss something like that. In other words, just have a judge vet that to ensure that it's probative and relevant evidence. What's wrong with that?
Well, because we have experts that are brought in now to explain away inconsistencies in evidence, right? And these experts, I would call them sort of pseudoscientists. Yeah, if you want to put science in there at all. So there's lots of methods of coming up with ways of explaining things that are inconvenient. So what we want to do, I think, is have people, they take an oath, they're supposed to tell the truth, and if there's a problem with that truth, they can explain it at the moment. If you give them time, in advance and you give them legal help, then what you do is you give them an avenue to avoid being held accountable for inconsistencies.
Well, and that raises see, this is the question for me, and maybe the panel can deal with this. The uniqueness, if you will, it seems the way the law treats a sexual assault trial as opposed to any other trial, any other crime. So for example, if a complainant comes forward in a fraud trial and the issue is credibility, as opposed to a complainant coming forward in a sexual assault trial and the issue is credibility, are we not presupposing that there's a different analysis on the credibility part? Isn't that
there's
what this...
there's no other complainant in a case in which we need to take this lengths to help them tell the truth. So let me say this. Let's not mask this into twin myths, okay? Here's the issue. I want to be very specific about this. It's not about text messages. It's about the subject matter of the offense. So, for example, on Monday night this week, there's an allegation of sexual assault. Any communications regard to that sexual contact, those communications are now subject to disclosure and a vetting of admissibility. That's unprecedented. The discussion about prior sexual history, that's just a mask here. It's a ruse. Any text messages or video or anything else that we've had prior about prior sexual contact, all that would have to be vetted through 276. You would never be able to use that unless you vet it through 276. This is about the subject matter of the offense in question. It directly arises from the Gomeshi case. So somebody has a particular contact. 5 days later, they write an email to the accused saying, "Oh, I had such a wonderful night. That was amazing. Thank you so much." The accused can no longer use that text message because if the allegation is a week later, a month later, 5 years later, 10 years later, the complainant might not remember, and God forbid we should be able to cross-examine on that without vetting it because it might go to the twin myths, which is absolutely bunk.
But okay, well, let me ask this. Andre, using Joe's example there, is the difference... I have other words, but... if Bill C-51 is passed and becomes law, using Joe's example, the Monday night text messages after, is the only difference, if I understand correctly what the proposed legislation says, is now Joe as defense counsel will disclose the new text messages that happened a day or two after the Monday night alleged attack.
About the subject matter of the offense.
About the subject matter of the offense, and now a judge will go through it and just determine whether or not it's admissible. Am I oversimplifying what would occur now?
Well, there's 2 points that he made that I'd like to respond to as well. One is, why is it that we treat sexual assault offenses different from a theft?
Right.
And Justice Claire Loritzby, in her dissenting decision in Seaboyer, answered that question. She said, sexual assault is not like any other crime. In the vast majority of cases, the target is a woman and the perpetrator is a man in 98.7%. Unlike other crimes of a violent nature, it is, for the most part, unreported. Yet, by all accounts, women are victimized at an alarming rate, and there's evidence that an already frightening high rate of sexual assault is on the increase. The prosecution and conviction rates for sexual assault are among the lowest for all violent crimes. Perhaps more than any other crime, the fear and constant reality of sexual assault affects how women conduct their lives and how they define their relationships with the larger society. Sexual assault is not like any other crime. That was her explanation. Now, in dealing with, I've already heard Gomeshi several times, so you know what I've done is I've looked at the legislation, C-51, and I will give this to Joseph. You're right that it does have a twist and that the complainant has a status and can be represented by counsel, which is sort of unusual.
Who's going to pay for that, by the way? I mean, I'll be out there, you know, I'm a civil litigator, so if somebody's going to come see me, are they going to just now going to have to pay my bill for me to go to court now?
Yeah. Well, yeah.
Is that how it works?
Well, yeah. No, it would be the complainant's responsibility to pay the bill. She wants...
or legal aid. Like we have third-party standing now, so if there's a Mills application or you can have, you know, the...
Well, I just wonder because are some complainants going to be able to afford
Can we stay on topic for a second?
Yeah, no.
Let's talk about text messages about the subject matter of the offense.
No.
Is that something new?
No.
Is that something new?
I understand, but
I want
Andre and then Diana to respond to the scenario
Maybe
that I
you should
said
have invited me
about,
here.
about the Monday night, you know, exactly. Let's get to Joe's example. Am I right that the difference would be today with that text message, that important and relevant text message that Joe's referring to? One, he now has to he would have to disclose it, and two, a judge would now have to make a ruling as to whether or not it's admissible. Is
That's
that
correct. That's correct, under the criteria specified in the bill, which is to ensure that the probative effect outweighs the prejudicial effect. So yes.
So Diana, how then, what's your concern then, to, as you said off the bat, about wrongful convictions, about how this is going to change the complexion inside a trial? How's that going to make it harder or more dangerous to get the truth out in a criminal trial?
Well, I think one of the keys is where it clearly says that they're expanding the meaning of prior sexual history to include things of a sexual nature, right? So, and I have an example, which is sort of like, I read about it tonight from an appeal case that I think directly answers what you're talking about. It's how this, it's how that phrase, prior sexual history, is it prior sexual history? How prior are we talking, right? Are we talking about moments before, like right before the door closed and they ended up in the room alone? Which is, you know, I'm seeing this happen where that's considered prior. So, but I also wanted to quickly mention something about the corroboration that Mr. Marin mentioned. I think when we eliminated the need for corroboration on these cases, we increased the need to test the complainants because their evidence is the only evidence, their testimony. So if that's all we have, we've eliminated the need for the other one, which, fine, I mean, if that's what we need to do, we need to do it. But it means, I think, that we have to increase the testing of that evidence, because that's all we have. It's like, we can't we can't be in that box where this event happened. So what we need is the narrative. How did they get in the box, right? What led to the sex? What happened afterwards, right? These things are relevant because the trier of fact, whether it's a judge or whether it's a jury, they need to get a sense of these people to be able to determine who they think is credible. So this expansion to sexual nature means that we're not just talking about whether or not somebody else is a virgin or not. Like, you know, we're not talking about how many times they might have had sex with this person prior. We're not talking about anything flirtatious, right? Text messages that contain, like, you know, stuff saying, had a great time. That's of a sexual nature, right, if they're talking about the event. But the thing that I was reading today, if the reporter is accurate in what she said, there was an appeal on the case, the Drunks Can Consent case, from Justice Lenahan out in the East Coast. And it was put to the Crown on this appeal. The Crown is appealing an acquittal that they themselves didn't ask the complainant whether or not she consented, because that became the issue that we're talking about, right? Whether or not she consented. And the Crown said that she could not ask that question, whether or not the girl had consented to have sex in the taxi cab, because that would have opened it up to barred areas of argument in terms of prior sexual history, right? So if that quote is correct, we've got a prosecutor saying that asking a girl if she consented the moment of an activity, right, she couldn't do it because that would be prior sexual history. And, you know.
Well, that can't make sense.
No,
But
that's in the report, so I want to look into that.
I don't mean to hog-tie this, but the reality is I need, ladies and gentlemen, everybody to think about this from a common sense standpoint, okay? Forget about the dynamics of the nature of the offense, because I've seen brave complainants come forward and witnesses in horrific cases and testify and undergo examination in chief and cross-examination and be reliable and credible in all sorts of cases. But let's just think common sense. Two people have an activity. Any communication subsequent to that, right, or picture, or anything else is now subject to the scrutiny of the court and to argument by the complainant and their counsel. That is unprecedented. That is a disclosure on behalf of the defense that is not seen in common law. It is an incredible erosion. And what we are saying is that a complainant in a sexual assault case, male or female, is incapable of responding to questions about material that they wrote after the event in question or about other evidence about the subject matter of the offense. It's not that sexual assault cases are different than any other case. What are we saying? That we lower the threshold because of the nature of the offense or the gender of the complainant, and then we foist it upon the defense? Imagine what this will lead to as far as access to justice. Litigation is already expensive enough. We've got legal aid, which is chronically underfunded. Those who are barely qualifying for legal aid may not get funding for these types of applications, or they won't have counsel who'll be able to muster it. Or if you have to, God forbid, pay for your counsel, you have a new layer of access to justice, a new barrier to access to justice. This is a monumental shift. And when you drill it down to that one issue, legislating that an unconscious person can't consent is literally stupid.
Okay.
Of course an
All right,
unconscious person can't consent.
No, I know. We're going to... Well,
but that's not...
Let's go to that part, because
I think the debate is worthwhile. We're skipping over it here, and we're just glossing over it. The fact that we have to disclose communications or any other evidence about the subject matter of the offense to help the complainant testify and have their lawyer be able to make submissions on it, this is monumental. It is not something that we should ever glance at here and just say, oh, well, it's going to help make it easier for complainants. It's going to lead to wrongful convictions.
All right. So, Andre, because I know Joe, and
he won't stop.
He'll start crying. He will start crying in a moment if I don't let you talk about this. So, no. But let's, all kidding aside, about Joe's point, the broader point about defense disclosure here, because that really, as Joe says, and I think
on this point,
on this particular point, why is the concern does not have merit to you, Andre, with respect to what Joe's saying, given the fact that the argument is how this, to use the words, the monumental shift, what will this now do not only to the accused, the justice system in general, for every accused now to have to put that evidence to the Crown beforehand?
I think what we're forgetting here is that there's no arbitrary use of those messages. They are guided by the provisions of the bill, which we haven't talked about yet. But the judge, in deciding whether to allow the messages to be used by the defense counsel, needs to consider first the interests of justice, including the right of the accused to make full answer in defense, society's interest in encouraging the reporting of sexual assault offenses, society's interest in encouraging the obtaining of treatment of complainants of sexual assaults, whether there's a reasonable prospect that the evidence will assist in arriving at a just determination of the case, the need to remove from the fact-finding process any discriminatory belief or bias, the risk that the evidence may unduly arouse sentiments of prejudice, sympathy, or hostility in the jury, the potential prejudice to the complainant's personal dignity and right of privacy, the right of the complainant and every other individual to personal security and to the full protection and benefit of the law, and any other factor the judge, provincial court justice, and justice considers relevant.
So stop right there.
It's a weighing of evidence.
If you were a judge at this moment in time,
yes,
and the application was brought before you, and you read out those criteria, as you just read them out now, I was thinking, if I was a judge, how in the world am I going to do that analysis? Is it cumulative? Does each one have to be looked at? Which one has more weight? It sounds very onerous to me for judges.
It is onerous, and it has to be onerous because it's a thought process. You can't, it's not a knee-jerk reaction. The current Section 276 has very similar criteria and has been in existence for many, many years, and that's the provision which was challenged in DERA that I prosecuted in 1993 and was found to be constitutional. I just want to add one thing, because we've talked about Gomeshi. And I went through this exercise in Gomeshi of extracting every email message that was put in evidence and how the judge treated it. Now, if Bill C-51 was in existence, the defense would have lost the element of surprise. In other words, you remember this message? No? Well, here you go. Oh, shoot, now I remember. So you missed the element of surprise. But the content, the way it was used both by a defense lawyer and by the judge, would have survived, in my opinion, would have been allowed under C-51. Yes.
So if each one of those emails
yes.
in Gomeshi had been put to that, you believe they would have been admitted at that time?
Well, listen, one of the complainants expressed the desire to, quote, fuck your brains out. I think you're magic. I love your hands. So this was used not to prove that she was more likely to have consented, but it was to prove that what she was saying in court and in statements to the police were inconsistent with what she put in the emails. And it goes on and on. You kicked my ass last night, and that makes me want to fuck your brains out tonight. I mean, how do you get around that? And the judge very carefully didn't say, oh, then she must have consented. He just said, you know, I have a hard time here reconciling what you have in these texts and emails with the testimony you gave to the police and what you're saying in court.
What's your name, sir? Sean, go ahead. Talk into the microphone.
With respect to giving the judges the power to make these decisions, I'd like to take one step back and just go to the provisions for prosecuting domestic assault. And in those cases, the judge, there's the idea that there may be activist judges in the courts in Ontario. And the question is simply, with regards to the sexual assault and the changes to the legislation which we're discussing, do you really think it's safe to leave this with the judges, given what we've seen in domestic assault enforcement, where somebody who has a strong defense might still face a prosecution, a successful prosecution, and further,
all right, Sean,
the last comment is, do we still have the assumption of innocence in those cases? I don't think we do. I think we have a de facto assumption of guilt which somebody has to prove themselves innocent to, and this speaks to allowing a judge to get rid of certain evidence or to include evidence. Okay. And I just want to
thank you, Sean. Thanks for your question. Appreciate it. Do you want to respond?
Well, you know, our judiciary is far from perfect. I mean, just on Monday this week, for example, a Quebec judge had to withdraw from a case, sexual assault, because he said, quote, we can say she's a little overweight, but she has a pretty face, huh? He went on to say that she was possibly even a bit flattered because maybe it's the first time a man's been interested in her. So, you know, it goes both ways. So you get some judges that are obviously completely out of line, like this judge. You know, pretty face, but a little overweight, and you got flattered. So maybe you like the experience. Our judicial system is independent. I think it's a good one. It's subject to appeal, oversight, review, in many instances, and we just got to do the best to make it work.
Can we go back?
I think Diana was going to make a comment.
Sorry, can you just give me 1 second?
Yeah, go ahead.
Okay, let's go back, because I heard a term being... Relax. You're not moderating. Element of surprise. My head will pop off my shoulders.
I've got an email here.
I have blood pressure issues.
I want to put an email.
Raise your hand if I can speak for a second. Okay, so we heard the term... We heard the term...
interrupt the other speakers.
No.
Element of surprise.
I'll give him my time.
The complainant wrote emails and messages. So in order to alleviate the element of surprise, has anybody got that?
Yeah, that's right. That's right.
What element of surprise? They wrote it. They wrote it.
Right. No.
I need to help them remember what the hell they wrote? Are you telling me that? I have to pay. You as the accused have to pay me to help them remember.
No, the element of surprise is on the crown, right? I mean, let's be...
No, it's not.
It's on
crown.
another judicial officer.
No.
No, that's who's surprised. That if they don't know,
they don't have to be surprised by it. This is what goes on in common life. They know how to litigate cases.
But it was like,
it's to help the witness, the complainant, testify.
No. I mean, we have a very famous case in this province. Very, very famous case. Ken Murray, who was Paul Bernardo's first lawyer, found the tapes with Karla Homolka and didn't disclose them because he wanted to use the element of surprise to cross-examine Karla Homolka when she was on the stand. The courts had a problem with that. Do they not?
That's real evidence.
What's that?
It's real evidence of a homicide at the time, video of it.
Right, well, but the emails or the text could be argued to be real evidence of
a lie.
Of lack of
It's the real evidence of a lie.
Yeah.
Is what it
of
is.
lies, real evidence of lies.
Yeah. But now what you're going to do is put it into tri-party litigation where the complainant will have a lawyer, and then after the motion, and Andre's right, Many of those text messages in the Gomeshi case would be allowed in, but then the lawyer's going to explain to them, well, you're going to say, well, that was, just part of the way I was dealing with the abuse and all this other stuff.
And they bring in an expert, one of these experts who explains away all the inconvenience. And then also, they have their own lawyers talking to them, explaining to them how they can, what excuses they can come up with. They've got all of these support workers, all of these, advocates who go in and comfort them throughout the trial. And you can hear the words of these advocates making it into statements under oath. When you're asked a question, why did you do something? You don't answer it because women sometimes do this, right? When they answer that, they're giving us advocacy statements. But in terms of what I was going to say before, and just to move this in a different direction, I think that this legislation is a response to public outrage. And the outrage was generated through cases like I mentioned, the drunks can consent, and the coverage that's gotten, and all of the advocates getting protesters out, and then also like this one with the outrageous comment made by the judge. I think that was in Montreal, right? Or it was in Quebec. Mm-hmm. So all of these cases, like you said, there are ways of dealing with this. You make a complaint, you appeal it. The CJC can be used by the lawyers who are present, who understand the process. But making these into a huge public outrage, and the internet is an outrage industry, that we are creating a panic that is being converted. There's been lots of talk over the last few months about public faith in the legal system, right? Well, first of all, I think that it's good if there's a little bit of concern about the legal system. There should be a little bit of hesitancy to run to the police over everything, right? That if you can work it out on your own, you should. People generally don't trust cops. They generally make lawyers jokes about why they'd be better off dead. You know what I mean?
Well,
these are things that have been going on for a long time. Everybody knows lawyer jokes, right? And we have a mistrust for the legal system, which I think actually helps people to resolve their own problems when they can, right? So we want to keep the system being used for things that really require it. But recently we had this case of the 3 Toronto cops where the reverse question was asked: does the legal system have faith in the public? Because they had opted for jury and then reselected for judge. And the reason given, they were questioning, how do we make sure nobody on our jury panel is going to #believe? How can we be sure that we're not going to have somebody who'll throw the whole thing off because they don't want to give this person a fair trial? And that's an intriguing question. Should the legal system have faith in the public? Because if you look at the last month, all of this Me Too stuff, sure, it's great. Some of these people are being identified and being dealt with because of this, but there's a lot of false allegations going on out there as well, and the public doesn't care.
Well, let me put a question, sir. I'll get to you in one second. I just want to put this, Andre, to Joe's point about something that came to mind. As a Crown attorney, you're the Crown attorney in a case. Would it not be your responsibility that, let's assume there are text messages and emails between the complainant and the accused. You as the Crown attorney, is it not your responsibility to properly prep the complainant for his or her evidence, to ask that question beforehand? Are there text messages? Did you text the accused after the alleged assault? Did you email them? That to ensure that they provide you with that disclosure and it's not coming from the defense?
Yeah, absolutely. I think absolutely there's a duty to do that. But bear in mind, I mean, the way Joseph talks is that we have recollection of every single email we've ever sent. Some of the emails were in the Gomeshi case were from 2003. Do you remember all the emails you wrote in 2003? No, I don't remember all the emails I wrote in 2003. Gomeshi obviously remembered. He went through his search machine and found them. So, and to answer the point made by Diana, where she says, oh, it's outrageous that they didn't go to a jury, they had to choose a judge alone, these Toronto cops. Well, that's proof that the system works in that there were options, and they chose the best option that they thought would serve their interest, and they got acquitted, all three of them. Same thing in Gomeshi. The system worked the way it should. Gomeshi got acquitted. He didn't get judged by the court of public opinion. He might have been judged by the court of public opinion, but that didn't land him a conviction or jail. He was found not guilty of the offenses. So the examples were provided, I don't think show a system that's flawed. I think it shows a system that works the way it should be working.
Well, in those cases of acquittal, though, I just want to point out that the loss of faith in the public is relevant, right? Because it's the outrage of the public that's being used to push through this bill, saying that people aren't happy that we're not getting the convictions. So you kind of skipped the point there. The reason that we're designing bills to satisfy the public is because the public, I think, can't be trusted.
Go ahead, sir. What's your name?
Silvano del Rio. Mr. Moran, I have a bit of a problem, in fact, a big problem with something you said, and maybe I misunderstood. But you said it has to be hard for the accused to be able to put in effect, his defense. Now, that statement, coupled with the, you obviously know that, the huge cost of defending oneself from what can be, and often is, a completely false allegation. Why does it have to be hard and go through third-party applications, having now the lawyer for the complainant, not just the crown attorney, and having all sorts of battles to admit evidence? Why? Why does it have to be hard to put in a defense?
I don't believe I said that. I said that the criteria has to meet what's laid out in the criminal code and in Bill C-51. The presumption of innocence exists throughout the trial. The accused is presumed innocent till proven guilty beyond a reasonable doubt. And I don't agree with the vast majority of these cases are unfounded. I think the vast majority of these cases are very hard to prove and lead to a lot of acquittals because of the rules of evidence and that benefit the accused. We will live in a system where we would prefer 99% of the guilty to walk than 1% of the innocent to be convicted. That's the basis of our criminal justice system. And that's what we see here today. Now, Bill C-51 has irked and upset, as you can see, many defense lawyers, because it provides another hoop to jump through. But C-51 is an extension of DARA. DARA survived a constitutional challenge, and C-51 will survive as well. And I don't think that it's doom and gloom to disclose the text and have a judge decide whether they are sufficiently probative to be allowed into the evidence. And as I said, I looked at every single message sent by the complainants, the three of them, to Gomeshi and news of the trial. And with the exception of one slight little slip by the judge in Gomeshi's case, they were all used to impugn the credibility of the complainants because they contradicted in their statements what was in the email. So that's proper use, and which would be allowed under C-51, and which would have still led to the acquittal of Gomeshi.
So what about that, Joe?
Well, who knows if it'll still lead? I mean, now that you have to disclose and go through this whole process, imagine how a complainant can now retailer their evidence to address what is an attack of their belief. Think about it.
Okay, I'm going to answer the question with this. One of the messages said she wanted to see Gomeshi fucking decimated. The guy's a shit show, time to flush. So the complainant will have to get out of that corner. How the heck would a complainant get out of that? Joseph makes it sound very easy. Oh, the person would just make it up. Well, it's a little hard to explain how you want an accused to be fucking decimated. Two complainants had 5,000 emails exchanged between them, which led the judge to conclude that it was a case of collusion. 5,000 emails. I don't think I've ever sent anyone 5,000 emails, ever in my life. So how do you explain that one?
Okay, but we're dealing with, I appreciate your position, but the vast majority of cases will not have the type of content that we have in this case. This is really an extreme. It may be 5 emails, it may be 2 text messages, it may be a card, and in my humble opinion, from my experience, it will afford an opportunity for a complainant who is firmly entrenched in their position with the assistance of a lawyer. And I'm not saying we're the best things in this system, frankly. Sometimes we're the worst in this system, but will allow a complainant with the assistance of counsel and significant foresight to now tailor evidence to address these emails, text messages, or cards ahead of their testimony. And when we talk about the element of surprise, Yes, if it's 14 years, you may not remember your email, but maybe then again, make the complaint a little bit more timely if you'd like to. And I don't think that is the defense's obligation to deal with.
I want to make a comment just on this point that was made by Mr. Marin about how was this person supposed to remember an email from 10 years earlier. And there are definite problems with historic allegations. But the thing is that you have to remember that people may be mistaken about a sexual assault because memory can be really tricky too. So even if they can't remember, the important thing is that they're obviously unclear on what the nature of the interaction was. If that email said, I had a great time, and they've forgotten about it, maybe they did forget it, but they also forgot that they had a great time, right? So their mind may have rewritten this. So those are things that are important to catch. Like, you don't have to remind people what they wrote. What you have to do is you have to determine the reliability, not just their credibility, but the reliability of their evidence.
Yes, sir.
My name's David, and I guess I had a couple of questions. The first one was, it seems one of the reasons apparently, I'm gathering anyways, that this was put in place was that there was concern that neither the judge nor the jury could contemplate and properly assess such evidence because they would be biased. There'd be an inherent biasness that would rise up and you wouldn't get a fair trial. Well, if there's a biasness in all juries in Canada and a biasness in all the judges in Canada, then doesn't that question the system itself? That's my first question. And the next one is, I don't think that's the case. I don't think Canadians are biased, inherently biased, and I don't think there'd be bias that would be raised if they hear the actual evidence. And another point is, if Bill 61 or Bill 51, if they want to apply this to a small section of the criminal code, and they view that and it's viewed as procedural fairness, then why not apply it to the whole criminal code and say that's procedural fairness, and just restrict evidence for every single fraud, burglary, everything, and just say, you know, this is one rule here. We want to be fair. We're applying it across the board, every single aspect.
And that was my question before. So why don't we start with your last question and deal with why not do that then? Exactly what he's saying. Make it that way. If disclosure all across the board. I mean, and if you're going to reciprocal disclosure.
Well, we're going way off from the actual C-51, but to answer the gentleman's question, the Supreme Court of Canada has recognized as a basic rule of evidence that the party seeking to introduce the evidence must be prepared to satisfy the court that it is relevant and admissible in every case, not just sexual assault, in every case. That's why you hear, if you watch television, objection, Your Honor, well, how is this relevant, right? So the party adducing evidence always has that onus. Nothing is automatically admitted. Now, in the case of sexual assaults, the code provides extra protection because there are prevailing sexual stereotypes. I mean, you remember the Toronto police officer's advice. His name was Michael Sanguinetti at the Osgoode Hall Law School to women to avoid sexual assault. Don't dress like a slut.
But isn't this...
no, it's stupid advice.
But that's off point.
It prompted, just because a woman dresses a certain way doesn't mean it's consent.
That has nothing to do with a text message a day after saying, I want to fuck you again. And I have to disclose that, and then I have to get it vetted through the complainant's lawyer, and now she has an opportunity to deal with it. It is completely different subject matter. I absolutely agree with you that that is stupid advice that a police officer should give. But let's not mistake stupidity with what is common sense rules of evidence, and why now we have a reciprocal piece of legislation for disclosure we've never seen before and doesn't exist for any other offense under the criminal code, but for the Gomeshi case. Because I'm telling you, if that case didn't occur, we wouldn't have this legislation. You tell me if we would.
Let me move on.
Yeah, no, I disagree, because if it was to tackle Gomeshi, Parliament did a really shitty job, because everything that was allowed in Gomeshi would have still survived under Bill C-51. So our parliamentarians don't know what they're doing if they're trying.
Well, how do you know? I guess how do you know?
Sorry,
it would
when
survive?
was it drafted? Was it drafted pre-Gomeshi?
No. How do you know it would survive based on when you read out? What is that? Was that a 9 or a 10-part test?
We're in fantasy land
that a judge has to go through, and to be able to do that. And let's talk. And I want to move to that part of this.
I'm happy to do that. Justice Horkins in Gomeshi, because you have to look at how was the evidence used in the courtroom. to decide whether or not it was used inspired by sexual stereotypes or whether it was used for proper use. A couple of examples, Justice Horkin says, the extreme dedication to bringing down Mr. Gomeshi is evidenced vividly in the email correspondence between SD and Ms. de Couture between October 29 and 2014 and 2015. The two complainants exchanged approximately 5,000 messages. While this anger and this animus may simply reflect the legitimate feelings of victims of abuse, it also raises the need for the court to proceed with caution. Ms. de Couture and SD consider themselves to be part of a team, and the goal was to bring down Gomeshi. And he found, because of that, there was collusion among the complainants. So the judge here is
But that was after, but excuse me to interrupt you, but that was after he heard all the evidence. What I'm talking about and what Joe was referring to, because I want to get into how onerous this is going to be for judges, because it seems that it's very onerous as it is right now when we talk about justice and what judges have to do. You read out, Andre, about 8, 9, 10 criteria that'll take place pre-trial, before there's any evidence.
This has been in the code since 1993, I believe, the criteria. So judges have been living under this regime on past sexual behavior of complainants.
Past?
Yes, past sexual. Yeah, but but the question is, isn't this too onerous for a judge, beyond the ability of a judge to reason? And I'm saying the provision I read out has already been in the code for many years, has survived constitutional challenge in the Supreme Court of Canada, and we pay judges over $300,000 a year. We expect them to be smart enough to go through these criteria.
But and I'm sorry to keep, look, Andre, I'm sorry if I'm so hot on this, but again, prior sexual history is different than communications about the subject matter of the offense. That is where I am stuck on. And this criteria, what I'm hearing about the Justice Horkin's decision and other decisions is, our system's working properly now. Justice Horkin's got it right. We have rules of evidence. Judges know how to instruct themselves on admissibility and how to apply evidence as to and give it weight. So why do we need this? Why do we need this new layer? Why do we need to now handcuff the defense and give this element of disclosure? We don't. And I am a defense lawyer who's been practicing for almost 25 years. I do have to say, we are quite blessed to live in this country, and I know we have problems with this system, but by and large, we have a judiciary who wants to try and get it right. We have prosecutors who want to try and get it right, and who generally do try very hard to work with the defense to make the right decision. We are quite lucky in this country, but we need to be careful that we don't create legislation and barriers to access to justice simply on certain cases that cause the ire of certain elements of our community. And that's what this legislation is about, that one point. Because when we talk about elements that we're going to add in to dress up Bill C-51 like it's somehow necessary, an unconscious person can't consent, it's like it's idiocy. Of course, an unconscious person. What they're addressing is incapacity arguments. And somebody who's incapacitated can't consent, but we want to legislate the obvious in order to mask what we're doing to accused people by way of these particular elements, which is the disclosure of relevant material now, which is going to be subject to scrutiny, which frankly will pass through admissibility, but will rob the accused of their cross-examination in cases. Well, I think it's going to have a detrimental effect.
I want to note, because it's been said that this is already decided law, that this is not a problem whatsoever, except for that this bill itself has in it its own charter statement saying that it may cause issues in terms of Section 7 and 11D. It says right at the beginning that there may be questions of constitutionality of this law. So it's not actually. They acknowledge it's not completely decided. And one of the points made at the standing committee by one of the lawyers who did a presentation, was saying by having to put your evidence in and run it through this process in advance, there's also the question of you don't necessarily know what evidence you're going to need until the person testifies. So you don't, you may have a bunch of evidence and some of it you use and some of it you don't. It's not until afterwards. And they suggested that at the very least we could try to move these applications, if they have to be made, to mid-trial, so that the complainant would actually testify first, and then you have to do an application in the middle. But because one of the points is that, why are you wasting time with an application if in the end the complainant doesn't say the thing that you thought they might say, and you don't need that evidence?
Yes, sir.
Yes, good evening. My name is Patrick. I'd like to know where the other half of this bill is, the one that puts people in prison for knowingly false accusations of indictable offenses, and why aren't they being enforced? Just to give you a little rundown on myself, my ex-girlfriend is currently on peace bond because she could have killed me when she assaulted me. She targeted my brain injury. The police charged her with assault, okay? And so that's that. Even when she was on recognizance, she breached several times. On my birthday this last summer, she tried to run me off the road a little after midnight. The Durham Regional Police Service response was to give me a breathalyzer and make a whole bunch of comments about me personally. That was the response to my complaint. This is why she's on recognizance, by the way.
What was your question? What did you want to say?
My question is, where's the other half of this bill? That's my question.
Public mischief is a criminal offense in the criminal code. So if you report an offense that didn't exist, you can be investigated and charged with a criminal offense. That's already in the criminal code.
What's the stats on that?
Yeah, statistics.
With all due respect, I've done a little research on my ex-girlfriend. In the last 30 years, she's made well over 100 knowingly false accusations, including sexual assault against doctors, people, other doctors, professionals, myself, even the police officer.
Well, I think
pulled her over
statistics,
one time.
statistics are used.
To nail him with sexual assault because he was going to give her a speeding ticket. She got out of that. Now, I don't know what the hell's going on with all this baloney. You guys can, talk to your, blue in the face, but I'm on the ground, and a lot of guys are on the front, kind of on front lines of this stuff, and we're taking it in the neck and the back and everywhere else. Meanwhile, you guys are, lawyers talking about how much money we can get out of these guys.
Well, if we're making bills based on, statistics and problems with a lack of reporting and a lack of prosecution and a lack of convictions, I would say that false accusations are well beyond sexual assault in terms of those low statistics. There's almost never convictions for false accusations, and yet we know they happen.
Can I go ahead.
Yeah, there's one I would like to address that has arisen a couple of times, and by Joseph, and he's saying that there's an amendment that for the purpose of this act, no consent is obtained if the complainant is unconscious. He keeps saying, it's obvious, it's obvious, it's obvious. Well, it's not that obvious, because that went right to the Supreme Court of Canada, and there's a dissenting decision saying that by 3 judges out of the 9 that disagree with that. So that's
why misrepresenting that case. That's not a fair representation of that case. The question was whether or not she could consent in advance. The complainant didn't even want him charged anymore. They did this despite her. She had advanced consent.
It happens all the time.
To a kinky sex. It was a kinky sex case. It's a really interesting one to read, actually.
Yeah.
And they were so interested in this question about whether or not you can, in advance, tell somebody that they can have sex with you after you're unconscious.
So
in a BDSM
the point
case.
That's being made is that it's not obvious, and the Bill C-51 had to clarify it and to say that the majority in the case was right and the dissent was wrong. So it clarifies it. So it's not, oh, it's so obvious. Why is it in the text? Why is that in C-51 if it's so obvious? Well, it wasn't obvious to 3 out of the 9 justices.
It wasn't obvious to the complainant. She thought that she had the right to do that.
We can't all the time means
it's
nothing.
A totally different case, and it's out there to mask what is otherwise an erosion of an accused ability to defend themselves in sexual assault cases, in my opinion.
So you think that complainants can be unconscious and still consent to sexual?
Is that what I said?
Feminists.
Hang on, let's everybody relax. Let's
Yeah.
everybody relax.
Yeah.
It's a spirited dialogue. I'm at fault for that, but let's relax.
Feminists were against this part about the unconsciousness because they recognize, like Joseph mentioned earlier, the problem is how drunk is too drunk. That's the thing we need to determine, and they didn't like this, including that an unconscious person can, because that's obvious, and they were worried that judges would say they have to be unconscious for it to be far enough. Right?
Well, yeah,
there's a lot of good law on this.
Courts have already said many times,
Yeah,
right?
yeah,
that I wrote down here that they never disputed the fact that unconsciousness precludes consent.
That's right.
right?
There's lots of good case law on this. Cases can be litigated very properly on capacity issues. We have toxicologists who testify. There's lots of good ways of handling this.
You're saying we don't need that legislated?
In my opinion, it is pandering. It's something out there to hide something else, in my opinion, which is a direct hit to an ability to defend yourself. And I just want to go back to false accusations for a second, because let's not gloss over that for a moment. Our system is not perfect. So if somebody's accused, unfortunately, they most of the time have to retain a lawyer. And in some percentage of cases, accusations are fabricated. The percentage of which the person who fabricates an allegation will be pursued and prosecuted is infinitesimal. Absolutely infinitesimal. And in fact, they can come back once, twice, 3 times, 4 times, or 5 times and make continuous allegations, and I've defended them, I've been involved in them, and we have a double standard. And when you are involved in defending cases that arise out of high conflict divorces, you will see motive to fabricate screaming out at you. And so we need to do something about that, and that needs to be dealt with. And the problem is, whether it's, because I got to tell you, in those cases, men are learning the tricks too. So I have female complainants as well. We have to be alert to the issues, and law enforcement and prosecutions have to be alert to it.
I want to move on to what this bill is going to do to judges, because, correct me if I'm wrong, but it appears that all I read about, and again, maybe again it's since Gomesha, we always seem to use that as some sort of mark in time, that it's harder to be a judge now in a sexual assault case. And we have these bills. We have Bill C-337 in Ottawa, Judicial Accountability Through Sexual Assault Law Training Act, where judges have to be trained now. So the question I want to put to the panel is this not, and especially, Andre, and I thank you for it, reading out all the criteria that a judge has to go through, is this law now not going to make what appears to be in this day today a very difficult job for a judge even harder now?
Yeah, and it shouldn't be an easy job when you're making $300,000+ a year. I mean, we're expecting our judges to be intellectually capable, and I think they are. And more we're seeing legislation that forces judges to provide detailed reasons, and this bill C-51 also says that, so that they are reviewable on appeal. Could we be quiet? Could we be quiet, please? Thank you. I remember when I was a Crown Attorney, there was a judge who, when he used to convict, he used to say, I've considered all the evidence, the totality of it, every single bit, every single witness, I've listened to attentively. I have no doubt at all, reasonable or otherwise, that he's committed the offense, guilty, and without providing reasons. And the way the law is evolving now is we're putting an onus on judges to explain the reasons, to explain, as Horkins did in looking at the text messages, how are you interpreting it? Are you interpreting it using stereotypes? Or are you using it according to the rules of evidence? And it provides for a greater transparency for the judiciary and allows for us to be able to judge the judges in a more open process. Now, do I agree with that judges need increased training with regards to sexual assaults and myths and stereotypes? Yeah, I do believe. I just read you a case came out on Monday that demonstrated that this particular judge needed it. When I was a Crown Attorney, there was a whole week set aside on systemic racism in the courts and how if you're a visible minority, you're more likely to end up in jail. And so, we need constantly to remind ourselves that as human beings, we carry with us stereotypes and biases. And I don't see any problem with providing greater education to judges about the existence of those myths and stereotypes.
Diane, and the question let me ask you as well, is this not going to make a hard, what appears to be becoming almost an impossible task, even harder?
Yeah, well, almost everything is being called a rape myth now, right? And we've got lots of experts to explain to us why any activity, any behavior from a complainant is consistent with rape. What we don't have are people telling us what's inconsistent. We have nobody telling us if a woman says this thing, then okay, that's a sign of lying. All they're saying is every single thing she could say is a sign that, it would be a rape myth to think that's a sign that she was assaulted. I think we have a really serious problem with the way the media is engaged on these issues and judicial independence. I think the pressure on judges is huge. You can see in some of the leading cases in Horkin's decision on the Ghomeshi case, in the Niznik decision from Molloy, and the retrial of Wagar after the Robin Camp fiasco, which was horrendous, that they had that entire sequence of events take place before the retrial, which put so much pressure on the judge. All three of those cases, they had to write paragraphs addressing the public pressure.
And is it possible, Joe, that the opposite, that following what Diana's saying, that putting these criteria now into a bill, saying this to a judge, these are the criteria you're going to be looking at, might make it easier, quote unquote, for judges?
I don't think it'll make it easier. I don't think it'll make it harder. I think by and large, we have excellent applicants for people who want to become judges. I think by and large, when you hear the aberrant judges who make these ridiculous comments, think about the thousands of cases that are litigated across this province and across this country. We have one pop out of Quebec, one pop out of the West, okay? So by and large, go to your courts. There are hundreds of these cases litigated every week, thousands every month. By and large, I think judges do a good job. It's not easy writing judgments. They take courses on it when they become judges. I don't think this will make it an impossible task. The problem is hyper-focusing on one particular area, trying to address myths based upon illegitimate studies. And I've had the benefit of almost cross-examining one of these so-called experts in a case where the Crown dropped it. Simply because the judge was quite astute on the particular issue, and there's good case law, and the judge was quite instructed on what are myths and what are not, and determined that it wasn't necessary for that evidence to be called. That being said, I'm worried about hyper-focusing on a particular area. I think it's good that judges should remind themselves about biases and stereotypes and all sorts of issues, because we live in a diverse society. But I don't like hyper-focusing on one area that's deriving from a particular moral panic that, in my opinion, doesn't exist.
Why don't we remind people of the myths, the rape myths? So let's go to the slide for one second. If you just go ahead here, because we put this together to remind everybody. If you could, whoever's on my my slides, if you can go forward. Technology. There we go. Keep going. Keep going. Rape myths, right. Keep going now. All right, so it started with the twin myths, right, from C. Boyer, that any evidence intended to argue that a woman who has previously had sexual activity is A, more likely to consent, or B, less worthy of belief, and that's credibility. Next slide. That came out of you and Chuck. Women fantasize about being rape victims. Women mean yes when they say no. Women can, will, should physically fight off a rapist. Women aren't harmed by rape if they're sexually experienced. Women are inviting, deserve rape by their clothing or conduct. Stranger rape is worse than acquaintance rape. And women who delay reporting are less worthy of belief. So those were the rape myths that were addressed all the way back in 1999. Mm-hmm. Right.
But now we have stuff like, if a woman says that she wants to have sex with you again, to think that that's not a sign that maybe it wasn't a rape earlier, apparently that's a rape myth, right? So this is the problem, is they're increasing. And in fact, in the appeal of what's called the Mandy Gray case, Mustafa Orarar, that judge was being told that it was a rape myth that she lied in order to advance a political agenda. And he said there is no myth called women lie about rape to advance a political agenda. And they all started laughing because she was there, and they started pointing at me actually and saying, ha ha, so is a rape myth, right? So this is to the advocates, these are rape myths as well, and those are being pushed into the courtrooms.
Is that what's happening? Andre, this new bill C-51 is now addressing what Diana's saying, the new rape myths?
No, not at all. I think that's, come back to Joseph's point, I agree that we have a high-quality judiciary. I think education would be a good thing. I don't think it's all that rare that, there's a case out west, there's one in Quebec. It seems every week there's a new one that pops up somewhere. It's not a rare occurrence that judges fall into these stereotypes, as I've just read out a case in Quebec, And even though I agree with Horkin's well-reasoned decision in Gomeshi, he himself appears to have slipped a little at one point. At paragraph 43, he said, quote, "The expectation of how a victim of abuse will or should be expected to behave must not be assessed on the basis of stereotypical models." Okay, so he cautions himself, I'm not going to fall into that trap. Having said that, I have no hesitation in saying that the behavior of this complainant is, at the very least, odd. He does exactly what he cautions himself not to do. He says we shouldn't presume a certain behavior after the offense, but I'm going to say it's odd. So who sets the standard of the oddity, the level of what's odd and what's not odd? There's no expert evidence called in this case. So he kind of slipped. He didn't need this paragraph. He had so much more to go on to find a reasonable doubt.
If that decision wasn't good enough, you're going to take that one little bit of, but I find it odd, and then say that, that's not acceptable, then our standard for judges is too high.
Well, he could have made the same result, came to the same result without making that statement.
Seeing acquittals overturned based on one misplaced sentence is horrendous. I mean, I've seen stuff where they had to go back to retrial, where if you were to take that paragraph or that sentence out, the rest of the judgment still stands.
Data.
You just yelled at somebody else for talking over you.
Well, you've been talking over me, so. Where's the stuff? Where's the data? Give me cases, okay? You talk about data, stuff, I read something in the paper. Where's the beef? Where's the beef?
You mentioned something you read in the paper too. So.
You've said that this is difficult, and that's okay. We have high-quality judges. You're probably right. We do have high-quality judges most of the time anyways. You've said it doesn't make a difference. Now, given that this is going to be much more closely tied to the offense itself, unlike prior sexual history evidence, and given that we handle the admissibility of evidence all the time at the trial itself, why shouldn't we just handle these particular things as they come up, rather than dealing with them all in advance from the beginning?
Because it's to provide for efficient use of court time, and it's to provide for that information which is unduly prejudicial is not going to cloud the judgment of the court because it's not probative but refers back to stereotypes. And, like I said earlier before, when defense counsel wants to bring a charter application to exclude evidence, they have to lay a basis, a legal and evidentiary basis, before the court allows the motion on a voir dire, on a hearing, to proceed during that case. So it's not automatic. There has to be notice to the Crown. There has to be a legal and factual basis put before the court to allow the court to say, I'm going to let you proceed with your charter application. So it's not all that unusual that the court is asked to pre-vet something.
There's a big difference, though, isn't there, between a charter application and question 803 of a cross-examination in those circumstances, isn't there?
I'm sorry, I don't understand your question.
I mean, a charter application is usually pretty essential. It's a major point of what's going on, and it's going to be somewhat distinct. What we're talking about is something as narrow as individual questions, small pieces of evidence that are going to be used in a cross-examination.
I don't know. I mean, Joseph would know better as a defense counsel, but many cases live or die based on successful charter applications. If you exclude evidence that's illegally seized and that's all you have, the Crown's case is gone. I mean, it's very, very much part and parcel of a criminal case. It's very important, and many cases are lost because evidence is excluded because the police didn't respect the accused's rights.
I want to, Joe, in practical terms, anecdotal, without obviously naming anybody that you acted for. Could you think of any case where one of your clients was found not guilty based on how the trial went and the credibility findings that the judge made, that you would sit here today and say, if Bill C-51 was law back then, my client most certainly would have been found guilty. It would have been an opposite result. Is there anything anecdotally you can think of about that way?
I have some concern. We have to see how this plays out, because the judge will now play gatekeeper. We have to see how the stereotype, the myths are played out with respect to what I consider to be relevant evidence. I think if this was in place 5 years ago or 6 years ago, some of my clients might be in a different place right now because of the evidence having to be disclosed.
And can you give us a practical example of why that would have occurred?
My opinion is quite simple. If there are certain communications that will be disclosed ahead of the witness testifying, assuming a judge will rule it admissible, but the complainant has the benefit of counsel, I suspect that they would be in a different position explaining it. Right. And which could lead to a conviction unfairly.
Okay, and I take it one step further. Would it not be the exact same preparation now that the complainant will go through, that you'll go through with your client if he or she was going to take the stand? In other words, you've got full disclosure from the Crown, presumably, and you are now going to instruct your client in trial preparation how to answer any and every question that may come their way. Is this not going to be the same thing for the complainant now?
No. It's a different dynamic. Nothing ever stopped the complainant from having their own counsel. If they wish, they can go retain counsel. They don't have to disclose it to anybody to marshal their way through the system. That's always possible. And I've had cases, frankly, where the police do a very good job of investigation, ask probing questions about communications, and they're disclosed. And they can be prepared. The way I prepare my client is maybe different or similar to the way the Crown may want to prepare a complainant in a case. But this is different. We're creating a new level, a new process here. And there will be maybe a barrier to relevant evidence. We will mandate now that a complainant can have counsel and will certainly avail themselves of that availability of counsel. And if they say, I can't afford a private lawyer,
what happens?
They're going to get paid by us, by the taxpayer. It's going to be paid through the Attorney General's office.
Do you think that?
I don't think so. I think it would be a very exceptional case that you would see that.
I have not had one case where I've had to bring a third-party application where the complainant went unrepresented. The court bent over backwards to make sure that they were represented.
For any records or
I think it's speculation at this stage. I mean, we'll have to see what happens, but I mean, what's the threshold for legal aid? You have to have 4 kids and you're no more than $29,000 for an accused to be represented by legal aid. So I don't think the courts or the government will rush to fund a lawyer for the complainant.
All right, let's talk as we head towards the end of the debate here. Did you have another question?
Yes.
Oh, okay. Sorry.
I didn't want to take up.
I thought you were giving us a standing ovation already. No.
How come I get all the questions?
Yep. Well, because you've got the tough questions and the tough answers. But this element of surprise, and at the same time what makes this difficult, we have case after case after case which say that assessing credibility is one of the most difficult things you can do. It's frankly nigh impossible in a lot of cases, and the only thing that courts have reliably seized on as going to credibility is inconsistency with the facts. Now, in this case, if the defense has to warn the Crown and the complainant, who is represented in these preliminary evidentiary hearings, of all the inconsistencies with the facts, with these communications, etc., that they plan to raise, at what point are you making judges' lives untenable by depriving them of the ability to actually see those inconsistencies live and use those to assess whether
we can talk hypothetically, or we can talk Gomeshi, and the statements here, whether or not they had warning or not, they were devastating, those emails, and there's no way they would have wiggled out of it. Secondly, it's not unprecedented. If an accused wants to raise the defensive alibi, he must disclose it with details to allow the authorities to investigate the alibi. Otherwise, the trier of fact can draw adverse inferences. So, that's giving away full answer in defense. You can't keep that as a secret till you go to court. And so it allows the Crown, the prosecution, the police to investigate the alibi. So, I mean, there are cases where there is disclosure, and I don't see this here as being, opening the floodgates to all unjust convictions happening. I just don't see it.
Let me just address this in 2 respects. First of all, in order for a judge to be able to make a decision about admissibility, if this goes through, the defense will have to put through a proper foundation in which a judge can assess admissibility and relevance. So that will include an affidavit and, of course, some portions of the Crown's case, including possibly excerpts of the statement or the whole statement of the complainant, because there will have to be a sufficient foundation for a judge to be able to make those decisions. So I don't think that will be insurmountable in and of itself, but it will be a significant layer, and what I'm talking about is the disclosure of it, which is the significance. I just want to say one other thing. When we're talking about alibi evidence, that can be an absolute defense, and that is saying, when that robbery occurred at the Walmart, I was in Ottawa, not in Toronto, and these two people I was with. Completely different situation than helping the complainant with their own communication saying, I really loved the sex we had that night. I agree with Andre that we do have other examples of disclosure which I think are rationally connected to the defense that an accused is mounting, including charter applications where it's based upon Crown evidence.
Because you're saying one means it's impossible for me to have done it. So,
right,
the case ends right there, and here it's just going to go to issues of credibility, and it'll be way down the road.
Well, but you know, if for example, I'm saying I'm in Ottawa,
right,
and I have a video of me in a parking lot.
That ends the case.
You should disclose it because most people will look. The Crown will look at it and they'll go, oh, well, you know.
Right.
So ends the case. It's different than me disclosing a communication from a complainant about sex that I had 3 months ago for which she's complaining about. It's a completely different beast, in my opinion. That is the one area of objection that I am focusing on. I don't disagree that we have other areas of disclosure, which I think is appropriate. And I think well laid out charter applications help with the efficiency, and we can't bog down our system with unmeritorious charter applications. I think that's not helpful to the truth-finding process either. But this is a completely different animal, in my opinion.
Do we have other people who wanted to get to the microphone?
I guess if I can just say that much more narrowly.
No, you know what? I get to do this.
Your Honor,
for the very first time, I get to do this. Thank you very much. Okay, go ahead.
Hi. I had been listening to you about like our justice system being, you have complete faith on it. I have one question. How can we believe on our justice system when the Crown, who was prosecuting a sexual assault 4 months ago, is now a judge? Don't you think, I'm talking about, particularly about John McInnes. You know about him, right? Okay, John McInnes was a Crown.
Okay, you know what?
Can I?
I don't think, I think what we should do is stay away from talking about specific individuals right now. Only because, and I'll tell you for one reason, they're not here to be able to talk about themselves, and we don't have enough information.
And just, let me just speak as a defense lawyer for a second, so Andre's not. There are a lot of former Crowns who are judges who are far better at acquittals than defense lawyers. Okay, I gotta tell you, there are some Crowns who are outstanding judges whose margins of reasonable doubt are much bigger than some former defense lawyers.
And defense lawyers are tough because they know all the tricks that they used to play on the judges.
It doesn't necessarily flow that way. It really doesn't.
No, but some of them, the best,
it's not that it's the tricks,
as a Crown,
but
some of the judges that I would prefer to appear before were ex-defense lawyers because they took a very cynical view of the picture. But no, I agree with Joseph's comments.
That's not to say that somebody who goes to the bench may have a particular view, and they may lean more to the right and more to the left. And that is just, it's just our system. It's very hard to tease that out with people when we appoint them. And that's why this whole exercise is an exercise in human behavior and psychology. So we can't avoid that. But and I do say this as a staunch defense lawyer, by and large, we have a pretty even bench, whether you're a Crown or defense lawyer, because they do take that job very seriously. And there are biases sometimes, and that's why we have to remind them.
That's what I'm saying, that they're gonna have a biased decision when a person who is accused of sexual assault comes in front of them, and they have previously prosecuted in some of the points.
No, but they're saying in their experience
a lot of them rise above it. They're doing their job as a prosecutor, and look, I've had this experience in my, I've had just recently a case now where I've had an excellent dialogue with a Crown attorney who's withdrawing on a sex assault case. They wanted to go through it. We worked through it collaboratively. I made defense disclosure of stuff I was going to cross-examine. They were drawing, and if this person
you just proved now why Bill C-51 is going to work.
No, I'm not. No. I'm not forced.
He made it a mission.
No. I'm not forced to.
Right.
I
You
made
did
a
it- you
tactical
did it in that case
I made
'cause
a
it worked.
tactical decision
Right.
with a Crown attorney who I've known for 25 years, who I would trust my life to, honestly.
Yeah.
And if that person were to become a judge tomorrow, I would have no trouble running a trial in front of them. I trust them.
But isn't that interesting, though, Joe, that in that one case...
It's not that one case.
No, but
it's
a
a lot of my
tactical decision,
cases.
it goes right to Bill C-50, but you made it. It was your choice.
But that Crown didn't tell me, oh, by the way, this is going to the mist. I don't want the government of Canada to tell me when I have to disclose and when I make that decision on the part of my client. That is my right. And that is the right of the accused. And the government has no business in meddling in that affair. That is it. It's a dialogue between me and the Crown, and I have a right to defend my client as I see fit. I cannot run evidence which is presumptively inadmissible or is denigrating to a complainant or any witness, or is definitely irrelevant because of stereotypes. This evidence was highly probative, and I had an excellent Crown attorney I was working with.
Okay.
So I'm allowed to make that tactical
You made a
decision.
discretion. You didn't want it to be mandatory. You made a discretionary call.
It should, because
Tying
the whole
question
dynamic changes then.
The question about judges, though, just thinking about 337, Bill 337, to
Sorry.
re-educate judges.
No,
Sorry, just one
no,
other thing.
no, let
But the other
Diana
thing you have
speak.
to understand, I'm not just.
No,
the other
no.
thing is the Crown wasn't consulting with the complainant, by the way, in this case.
Okay.
Okay, now.
Thanks for the caveat.
I mean,
that was
this
very
concern
crucial.
that
Go on.
judges are like making these crazy comments, or the judges aren't good enough. I mean, if that's really the case and we're designing bills to re-educate them and stuff, then I'm kind of interested in why they're not taking all of their judges from the highly recommended pool, as we were told. And they won't disclose how many, but the Liberal government just took a whole bunch of people from the recommended, not highly recommended pool.
Oh.
So, you know,
interesting.
And they won't give us all the data on that. So it's kind of really, you know, hypocritical to be so, like, to not be following proper
maybe we
procedures
should
there, but
find out-
designing re-education judges.
Right.
They wouldn't have to
but
re-educate them
Diana,
if
to
they
your
got
point-
highly recommended ones. You know what I
But
mean?
to your
I suppose.
point, maybe when they take the course, we should get the mark and find out how they did on the course.
And the curriculum.
And the curriculum, yeah.
Yes,
I
sir.
think that's a very important point, not to see their exam, but the curriculum should be made public.
Yeah.
We shouldn't be known exactly what they're being taught.
Right.
And
I agree with
by
Andre.
qualified people.
Yeah. And wouldn't you want to know what they got on the course and the people that may have
Well-
failed? You know, like, yes, sir, go ahead.
Hi, thank you. So I come with the unique advantage. I didn't come here with a position or even know what I was coming into, but I've been able to see a pattern. It appears that there's been some agreement that false allegations exist, but yet there's very little convictions. There appears also to be some agreement that rape exists and some people are not reporting it. This law, does it make your job easier?
I'm not a Crown anymore.
Would it make a prosecutor's job easier?
I think
in
it
the
would
case of
make
rape?
a trial fairer, prosecution easier.
In the case of rape?
I think it would make a trial fairer.
Okay. And if you were trying to prosecute for false allegations, would this law make it easier to prosecute an act which is illegal, which might be just as bad as an actual rape, but a false allegation of rape? Would this make it easier for that or harder for that?
Good question. Would it?
This one, in one way or the other.
Is there something in place to equally protect the case of a false allegation, given the access is greater to make an allegation?
Presumption of innocence, proof beyond a reasonable doubt, probative evidence versus prejudicial. These are all cornerstones of our criminal justice system. They're there as safeguards.
Okay, but you don't believe what you just said, I can tell that. What I'm wondering
I
is,
do believe it. I do believe it.
but you're just saying things, you're not saying it meaning.
No, that's not fair. Why would you say that? That's not.
What I'm asking is, would there be something in place to protect an individual from a false allegation, since you're asking for information which appears to make it easier to make an allegation? I want to make it clear, under no circumstances am I saying that somebody should have an easier time of getting away with rape, but should somebody have an easier time getting away with false allegation?
Well, false, you're talking about an investigative issue, not a trial issue. So it's up to the police officers to do their job and to investigate these cases thoroughly. And if anything, there was a very long protracted series in the Globe and Mail called Unfounded about how the police presume that in far too many cases that the sexual assault did not occur, and have been reopening files because they've been using their own stereotypes and myths about sexual assaults to reject otherwise founded cases. So,
law fixes that problem,
No.
then that makes no sense in this discussion. This discussion is about if we have a false allegation and we have a law which makes it easier to get access, is there something to protect if that's a false allegation, since it appears that we're not convicting false allegations? I would argue that has an effect on people's lives.
I would like to add something here.
One other question
I
is
just
if
helped
that's
somebody
also-
to try and charge somebody with false accusations. It's the public mischief, and it's not just investigation. The first thing the police officer told us was that it requires prosecutorial approval. So it's not just the police.
No, I'm sorry, sir. No, you know what? I got a lot of people who want to do this.
False allegations because parents are not able to see children in that case. I'm wondering whether or not anybody is worried about children
Yes,
not being able to see.
yes,
and
yes,
whether or not there's some
yes.
sort of
There's another lawyer in this room, as well as I, that had a case where, upon an allegation of sexual assault, a 4-year-old and a 6-year-old were alleged by the police to be witnesses, which was absurd. And in fact, the statements that we found out a short period of time later had absolutely no evidence to offer. We had to go to court to bring a motion because on the undertaking, the accused was not allowed to have any contact with his children. We had to bring a motion. The judge was scared because the Crown was still arguing that somehow the children were at risk, even though Children's Aid had closed the file and said there was no risk. No, there is no protection for a father to get access to their kids that way. There's a bias
But
that
just a
needs to
minute,
be
Joe,
addressed, and then they have to run off to the family court, and good luck with that when you've got an allegation of sexual assault
but I want
hanging against you.
I want to go
Good
back.
luck. That protection doesn't exist for men or women in that situation.
Okay. I just want to go back to what that gentleman was saying to you, Andre.
And make no mistake
just
about
a minute,
it,
Joe,
it's
Joe,
happening to women as well.
Joe, please,
Lauren,
please,
Lauren,
no.
you're just the moderator.
No, yeah. But Andre, what the gentleman's question was about Bill C-51 that I think is quite relevant was the question saying that now, if a complainant comes forward, police now investigate, they now charge an accused, and now the defense, pursuant to 51, has to hand over the relevant disclosure. Is that now going to maybe give the police reasonable and probable grounds at that moment in time to charge the complainant with public mischief? Because now they don't have to wait for the trial. Now they don't have to wait for the evidence to go in. The defense has provided the evidence.
Absolutely. I could work both ways, absolutely. Absolutely.
But will it happen?
Well, I mean, you know, Joseph was telling a story about how he provided disclosure and it led to the withdrawal of sexual assault complaint that he was dealing with. And I've done the same as a Crown, where, you know, defense came in and we trusted each other, gave full disclosure, and then I pulled the charges. We all know the case of Michael Bryant, the former Attorney General, where his lawyer did the same thing, disclosed the entire case. And so to get back to your point, C-51 may actually, it could work both ways. It could influence the course of whether or not the Crown proceeds with the case or not.
All right, we're running out of time. Go ahead, sir.
Yes, I have a question anyways. I'm a youth worker. I work with teenagers. I've been doing that for the last 2.5 years. And since the summer, I've had caseloads where youth, females will come in where I get referred to, and it's either sexual assault, something to do that against like another male, and me as the intake kind of person and just dealing with them, obviously I have to hear their story and see their opinion, or you know what I mean, like I'm obviously not biased, whatever the case is, but then going into it and just interacting, obviously dealing with the youth, I may find out she was lying, and basically the youth, for my last, the last case that I had, basically the charges were withdrawn, and basically she had told me that she was lying, but she had called me and she said she doesn't want to go to court. They're here to subpoena her. What do I do? I told her, I mean, these are accusations you made up. They're very serious, and the courts take these things. They're like, you know, they don't play around with these type of stuff. So then, long story short, the charges were withdrawn, but nothing really happened to the male thing. He was kicked out of school. You know, a lot of stuff. He's already labeled still as whatever they want to label as, even though the charges were withdrawn. But you know what I mean? For these type of cases, And I mean, no one condones rape or anything. Like, this bill, I would think would maybe come into effect depending the scenario of a case. Like a Crown and a lawyer should be able to argue if a Crown wants to bring this whatever into a case, whatever the case is, they should be able to argue it. And if the judge wants to either admit it or get rid of it, then that, because there's already so much cases, then we have to go into the background and character, and there's a whole lot of stuff that I heard you guys saying before. But it's still, then what happens when something is unfounded and someone makes a false accusation, right, in a day? Because if that kid was found guilty, he was going to jail for a long time.
I know. The stress starts the moment you find out somebody's accusing you, and then it builds up when you're charged, and then you have to wait for a long time to get to trial, and then there's the financial expenses. I just helped a guy who had to go through 2 trials from the same accuser, and after 2 years, he was acquitted on both trials, and we went to the police to report her, and the police said, well, you got acquitted, you should be happy because the system worked.
Right, and these type of things, obviously, like I even had a youth actually, like last week, basically, I just heard about this, something with texting. He's 14 years old. He was with he broke up with his girlfriend, whatever the case is, but I think she must have had some naked pictures of her or something like that, and the naked pictures got sent to somewhere else. Now he was charged with, you guys probably know that, whatever the case is, and right now he's scared, right, a day, because like in a day, if he gets found guilty, he's only 14, he's gonna be labeled as, right, and a day, and his life is gonna be over, and a day, then for these type of things, like how does the courts and even the judges, because judges obviously have a strong view of certain things, they may see certain cases come in front of them, but for the youth that's charged with withdrawing, he already had a bias because he had a record on him, but the girl that charged him didn't, but it found out she was lying, right? So then how the courts really determine those type of things, because if this bill comes in and passes, who's to say there's not going to be people to manipulate these things in a day, right? They have sex trade workers. No one's not knocking, saying whatever they have to do, but you have sex trade workers that could take advantage of this just with clients, and you know what I mean, whatever the case is. It goes vice versa, but where is really something to input that to make sure that if this case is going to court, that it's looked at and examined properly, right? And we could say we have professionals. No one doesn't really know what really occurs unless it's a story. Something may match up, but no one really knows what really takes place. And a judge may just already have his own preconceived notion just on the synopsis he's reading. And
sir, listen, I don't mean to interrupt you, but we're almost out of time here. I want to try and get one more question in, okay?
That was my question today. So I'm just thinking this bill to pass, like, who's really going to look at it and say, who's going to stop people from manipulating this bill? Yeah,
I've been wanting to say something for a bit, and that sort of answers that. And what we're hearing all the time is, well, we'll wait and see, we'll wait and see. And from my perspective, helping the falsely accused, I think if we wait until people are being wrongfully convicted on a large scale, we've waited far too long. That we need to deal with this. When you know there's going to be a problem, one guy being wrongfully convicted on laws that we know are sketchy is one guy too many.
Go ahead.
Gotta get my thoughts together. So corroboration, sorry, you mentioned corroboration and how that was removed in the 80s. And I believe that was part of a push backed by, well, I've read Constance Blackhouse writes about it, and that the purpose of that was to help increase convictions in sex assault cases because they weren't getting the convictions that they wanted. And I've also read that since then, they're sort of finding that the rate of convictions hasn't really increased. And the rate of acquittals, by the way, is less than 10%, just so you know.
Well, no, I've got some stats here that from 2014, 3,000 sex assault cases were examined, 45% finding of guilt, 44% withdrawn or stayed by the Crown.
What the acquittals was what, sorry?
And I'm just seeing.
45 and 44 is 11 left over.
Yeah.
So you assume that there's
partial, yeah.
I provided a quote earlier from the Supreme Court of Canada where Justice Larouche had data before the court saying that it had the lowest conviction rate of any offense, but in any event. What is your question?
So where I'm going with this is the removal of corroboration, the requirement for corroboration was to get more convictions. So now here we are, since then we've had new precedents and new legislation to make it more difficult for the defense to defend themselves. And now we have this legislation to strip even more safeguards from the defense, from an innocent accused in being convicted. And also, you also talked a lot about judges and how we should, trust them. We pay them enough money, they should know what they're doing. Well, in my view, and I've read many, many cases, I support people who've been falsely accused. I spend a lot of time in CanLII, and I handpick, I go through the entire database, and I find that on average, 20 sex assault cases or sex crime cases a year have been overturned in a lower, just in the superior court level. So those are just the cases that have, convictions where they have been overturned.
Well, because
there's a lot of mistakes being made.
Juries are being
these are judge
not
only.
Instructed properly.
They're mostly judge only.
They're not instructing themselves properly.
So the evidence, the judge's decision and verdict is only going to be as good as the evidence presented to them.
Yeah, just go back to your first point about corroboration. First of all, you're wrong when you say that the Crown wants more convictions. It's not a role of the Crown to convict anybody. It's a role of the Crown to present a fair trial and to the court and to the accused. And to prosecute in the public interest. So it's not to get convictions, first of all. Secondly, the rule requiring corroboration made, with all due respect to you, absolutely no sense. Short of a rape in a bush where everyone's watching it and you have an independent corroboration, a sexual assault between people who are dating or have met at a party and so on, they don't happen in front of third parties. That's part of the problem.
Okay,
There's
but
no witnesses.
that automatically lowers the standard for burden of proof. And what does that say?
You don't need corroboration for theft.
We hear
you don't
people,
need it for fraud.
we hear crowns and media saying that the criminal standard of proof is extremely high and that nobody will be wrongly convicted. And that, is BS as soon as you remove the corroboration requirement, because you don't have to provide proof that a crime happened.
If you're gonna put back the corroboration, you might as well just get rid of sexual assault altogether, because you'll never get a conviction.
It shouldn't be in a criminal court. It should stay in civil.
Well, I disagree with you.
If I can just ask, are we okay for a few more minutes? Yeah. One or two more questions. Okay.
I just want to make a quick point about the historic allegations. I have a really big concern about people being able to accuse somebody with no corroboration or anything, like from 30 years ago and stuff, because I've actually seen cases where you're not being. It's not like you're accused of last Friday, right? You're accused of having done something once or more than once between a period of from 1983 to 1985. And so what are you supposed to do? You're supposed to come up with an explanation of where you were and what you were doing for a 2-year time span? Like this is a bit of insanity going on with that, and I think that's got to be addressed.
It may sound weird as me as a defense lawyer, but I did sit through the Cornwall inquiry, and the removal of corroboration makes it a little bit easier for those who are in vulnerable situations to come forward with allegations, especially if it's a child or a person who's been in a situation where they truly are a victim of abuse and are quite trapped. So the removal of corroboration itself, I think, was an important component to allow true victims to come forward and be able to redress what happened. That being said, we need to still strengthen and hold true to proof beyond a reasonable doubt and not put in the way extra barriers to being able to defend yourself, like Bill C-51, with respect to disclosure of relevant evidence about the subject matter of the offense. We need to be careful about due process, we need to be careful about investigations, and careful about safeguarding our rights to defend ourselves. But similarly, I am of the opinion that there are vulnerable individuals who suffer in silence, and we should not have bars to their ability to access justice as well.
By the way, one of the things I just tell you quickly, what I do for a living every day as a civil lawyer, and I do mostly defamation and libel work, I have more and more people coming to see me, most of them men, who've been accused of sexual assault, have been found either not guilty or the charges were withdrawn or dismissed, and now they feel their only remedy is to hire someone like me to sue the complainant for defamation for bringing the action forward in the first place. And when it was first starting to happen, it was like, well, this is going to be very onerous. And now more and more, we get the file, we get and to them it's just some way of getting that type of relief. And they'll always say to me, it's because I can't get any other relief. The system, I don't even feel good that I'm not guilty. I had somebody in my office yesterday, and we were talking about that. So,
well, imagine when there's a press release, right? Somebody's charged,
right.
There's a press release. When they're acquitted or the charge is withdrawn, there's no press release.
Yeah, that's part of the problem. Go ahead.
I don't think I have a question. There's too many questions. That's the problem, and not enough answers. I know rape victims would probably have a very difficult time coming forward, and they're very nervous, but I think people who have been falsely accused have the same amount of feeling of being raped. Double false allegations, convictions, the impact on the family. And my concerns are testimony is evidence, but the testimony of defense isn't. Also, the dismissal of all the evidence for defense is easily thrown out with weak grounds, and the verdict for guilt is also, the reasons are very weak, coming out of judges that are famous, you know, and known across Canada. So I don't understand how the bill is going to impact people who, you know, or bring more false allegations forward to bring convictions, but I'm hearing that there's not enough, there's not many convictions of false allegations, but to someone who's sitting in a prison as a result of a false allegation based on testimony, no evidence, all dismissal of evidence for defense, it's a total miscarriage of justice. I don't think it's taken seriously enough. And I don't have any confidence in the judicial system, but I have confidence in the truth. And so I think people just have to keep on speaking the truth of their own story, because I don't believe that the judicial system is going to get it right, even in 50 years. I don't. So I don't have a question. I don't have a question, but I have.
But you raised one issue though, which there's a trend going through. There's a case called WD from the Supreme Court of Canada from a long time ago about how you assess a defense, an accused evidence, and there's a line of cases now where you can see that an accused evidence, it will be commented on by the judges having resisted cross-examination, not being inconsistent, but is rejected because the evidence of the complainant has the ring of truth to it and makes more common sense, and therefore I'm rejecting the accused evidence. So there is somewhat of an erosion happening now with the WD analysis, which frankly leads to, in some cases, and I'm not saying all, an easier rejection of accused evidence, which may make it easier to convict those who are innocent. Although I've had the benefit of seeing other judges in cases of sexual assault where WD is very robust and they're holding very true to it. But there is a trend now, and there's a couple of cases that I think are going to be addressed by the Supreme Court of Canada on this. So there is a danger there in that regard, a very real danger. Thank you very much.
I've noticed that too, that they go through these 3 steps, and they'll try and get to the 3rd phase where they say it's a balance of like all of the evidence before them as opposed to the choosing of testimony. But that was actually an issue in the Robin Camp criticisms as well. Well, if you read the whole transcript from the first Wagar trial with Robin Camp, he says, well, if I believe the accused, then I have to acquit. Right? And the prosecutor said, no, that's not true. You can't just do that. But that is one of the elements. If you believe the accused, then you must acquit. It's literally what WD says.
All right, well, listen, I want to thank everybody. As we do, and every time we do these panels, we have solved all the questions. We have got the solutions, and we did it right here. And in case, you have some, I'm sorry, you see, you're going to officially close it off, right? Okay, go ahead.
If I can get a microphone, that's the full step. So I'd like everyone to give a thank you to Lone for being our moderator and to all of our panelists. And just to close things out, I have to do the obligatory plug for UTMIAS. Check out our Facebook page or sign up outside on the table. And finally, though Justin spent quite a bit of time on it, a bit more than we budgeted for, please do take a look at the Men's Shelter Project on CAFE's website. Other than that, have a good night.